May I, sir?
Yes, yes.
Good afternoon, participants. In our second session, we have with us Dr. Rajesh Kumar, sir. Sir has completed his PhD in Securities Laws in the year 2012 from University of Delhi. He has written many articles in his books on securities laws. These include corporate law, securities law, competition laws, merger, acquisitions, banking and insurance, and international investment laws. Sir has also participated in various conferences and seminars organized by various institutions and has also been a speaker in many such conferences and seminars. Today, sir will speak on technology and its impact on corporate laws, competition laws, and financial market regulations. Thank you, sir, for accepting our invitation. Thank you so much. Over to you, sir.
Yeah. Thank you, madam, for the invite and for the nice introduction. So today I will tell you about the interface or the impact of technology on corporate laws, competition laws, and financial market regulations. So as I already, madam introduced me, I'm working with the SEBI Institute in Mumbai. And so how we are going to proceed. Firstly, I will let you know about the background of the technology and the corporate laws. Then how the technology has impacted the development of the company and the laws, the regulatory part, and also the currently how the technology is impacting the regulatory, the regulations of companies. Then I will move to how the technology has like evolved with the competition law and impacting the competition law. And then I will tell you about the impact of the technology on financial market regulations. So that is the flow of presentation. Now, as a background, since you are all already, you have done your LLB, LLM, and now you are in PhD. So you must be aware that the company is the product of the capitalism, where like the two basic ideas. One is the freedom, second is the contract, sanctity of contract. So with these two ideas, the companies were emerged, the concept of company has emerged, and the features were added by the thinkers of the capitalism and mainly the legal part. So different features were added. Features like company will be like a separate legal entity, and as like as most of you were aware in the Salmon case, Lee case, in India Reliance case, where it was held by the court that company is considered as a separate legal entity. Like an individual, it can invest or it can do whatever the business as an individual we can do, company can also do. And other features were also added, like perpetual succession. Individual may die, but company will continue. And company will continue, the members may come, members may join, and company can file a case or case can be filed against the company. And then the limited liability, the liability, there is a choice, to limit your liability if you are forming the company. So all these features were given to the company to ensure the development of the company. But still the companies were not developing in the beginning, despite of giving the features, despite of liberal interpretation made by the judiciary, the concept of company was not developing. Then the important power which was given to the company at that point of time was the power to raise the capital. Before this power was only given to the state. That the states, like the countries, whenever they were in the need of money, they were issuing the securities, they were issuing the bonds, and this power then they gave to the company, which we know as the power of raising the capital, maintaining the capital, that is the corporate finance. Then they started finding the trouble with the corporate structure, and then they said, no, the time has come for segregation of ownership, management, and trading. But apart from, even after adding these features, the companies were not developing the way they thought that it will be developed. So then the scientific 1890 onwards, when Thomas Edison came with the electricity, other scientific inventions started, happening, major scientific inventions. So that actually led to the development of the company. So mainly in the US, it was the railroad companies and shipping companies which created the success story for the company, because investor at that point of time were not ready to invest unless the company was like having some sort of, ownership of technology, some sort of scientific invention, or some sort of intellectual property rights. So that led to, so even so, what I was just I was just trying to make is that the very basic development of the company was linked with the development of the science and technology. Why it is? Conceptually, as you understand, it is believed that, a concept, mainly a business concept, unless it has an idea of financial brilliance or technological brilliance, it is very difficult to, establish or, succeed an idea. So company by default, is an idea based on one of the innovation. And unless, so if that innovation is mixed with the scientific and technological innovation, then the company can create a success story. So that was the one of the important reason why the development of technology, development of science has influenced the growth and, development of the company itself. So financial brilliance, technological brilliance, and cost reduction through technology. So whatever can be done, through individual. So as I already told you, they gave a system of memorandum articles. So rather than individuals are going and entering into multiple agreement. Just you purchase the shares of a company, and it will be considered that you have accepted whatever is written in the memorandum articles and the prospectus, a document issued by the company for issuance of capital. So the scientific and technological development has created the company, reshaped the company, and developed the concept of company from time to time. One more important thing, I just wanted to highlight here is that all of you were aware, when the Gandhiji came from Africa to India, and he did movement in the Champaran state of Bihar. So there was a trouble with the indigo plantation and the farmers who were involved there. And at that, why the trouble occurred? The trouble occurred due to the Germany came with a scientific invention, creates that, it has manufactured indigo in their labs. So it was a scientific invention, and no leader or no person, even a strong leader, even a strong person, can fight with the scientific invention. So Gandhiji went there. The profit of the farmers got reduced due to this. So Gandhiji went there. He did the movement and he did everything, but nothing happened. Why? Because the scientific, the power of invention, the power of science was so high. Same happened with the Bombay cotton mills. Initially, there were many cotton mills here, but then the scientific development of polyester took place, taking the profit, taking the margin, taking the profit, and ultimately leading to the labor unrest because the profits were reduced. Similar thing happened in Kolkata in the jute, because the another product, the polythene, came. So wherever the cost-effective product has come, the science has created some, cost-effective product processes. Immediately, everybody moving to that, and that is like creating the trouble, changes in the system, in the law, in the regulation. So what I was just trying to highlight here is that the corporate structure, the establishment of company, the growth of company, and the success story of company was a result of, the different scientific inventions. The time to time scientific inventions, technological inventions has laid and paved the way for the development of the company. So moving further, how the technology is helping in the enforcement of the company law, as you understand the present day. So today we are living in the era of technology. The technology, through the technology, you can enforce the regulation. So corporate meetings, the example is previously, if you were aware, the meetings used to take place as per the provisions of company law, the place where the registered office of the company is there. मैडम एक लेक्चर है, लेक्चर के बाद लेक्चर है 3 to 4 4 बजे. Sorry. So what I was just trying to highlight here is that the corporate meetings, initially it was you need to go to the place where the registered office of the company is there. But now with the help of technology, right, NSDL, CDSL conducts meeting. And you are surprised to know, we are the training institute of SEBI at Mumbai. So many countries actually, many South American countries, many Arabian countries, they are just coming to us this our National Institute of Securities Market to learn that how India as a country has developed the technology where the meetings can be conducted online. So we are just taking the participant to the NSDL and then they are, witnessing it how we have come to that level. So corporate meetings, then corporate governance. So all the decisions, like as some of you may be aware that a listed company is supposed to make certain disclosures. So nowadays, like whatever is happening, if the information is a material information, some of the information is supposed to be disclosed within certain hours. Some of the information is supposed to disclose within 24 hours. Some of the informations are supposed to be disclosed within. So as an individual, it's like difficult. So they are taking the help of the software. They are taking the help of the scientific techniques. So it is also helping in the corporate democracy. Like previously, meeting of there is a provision in the company law. I'm just pointing here that now in company law 2013 there is a concept of the director representing a small shareholder. So 1,000, if in a company, if there are 1,000 shareholders, they can elect one person as a director. So how they can meet? Previously it would be a very difficult exercise, but now with the help of the technology, now it's very easy. Same is the decentralization of information, corporate compliance with the help of technology and artificial intelligence and shareholder engagement and empowerment. Why it is? Because technology has provided the speed, accuracy, transparency, right? And one more important thing, what is the latest development with respect to the technology and the company, that even the decision-making process, most of the companies, they are relying more on the artificial intelligence and software to the extent that certain legal research is going in the different jurisdictions where the technology can be appointed as advisors, and even now there is ongoing research that can the artificial intelligence and technology can also be appointed as a director. Can they replace human? Because as you understand, company law prohibits the three things. First, company law prohibits information asymmetry. Second, company law prohibits conflict of interest. Third, company law prohibits related party transaction. And fourth, company law prohibits that no director, promoter, or other person can make a private profit of a corporate opportunity. So the technology, through the technology, all these things can be done. So if let us say all the data is given to artificial intelligence software, and with the help of data analytics, it can come to a better conclusion. It can give a better decision. So in many jurisdictions now, the legal research is actually focused that how these three ideas or these three prohibitions can be better handled with the help of the technology, mainly the data analytics and artificial intelligence. And also, how it can protect the minority shareholder, the mismanagement, the frauds, and planned bankruptcy. If a company has adopted a technology, though as you understand, human being can manipulate the technology, can manipulate the code, but still the technology, the performance of the technology is better than the performance of the many human beings, howsoever intelligent he or she is. So that is the now, as like some of you may be aware that in securities market, mainly in Mumbai, the actual use of robo advisors are there, right? Many companies are getting created where you can take advice. So whatever information, suppose you want to invest in the share of a company, so a robot is there, all the information it will collect, all the data it has from the securities market, and it will give you not just advice, it will also give you the financial details, that is the known as financial analysis and or fundamental analysis and technical analysis. All the document chart will be given to you by the computer. And artificial intelligence, like every day since the technology is learning more and more. So these robo advisors, these artificial intelligence systems are frequently used by the big companies, by the big firms, by the big institutions in our country. Some of you may also be aware about the initial coin offering, initial token offering, as like initial public offering where you are offering through the document, the people are getting the document. Now, with the help of the blockchain technology, now you can offer through the coin offering or the token offering, or even equity crowdfunding is possible with the help of technology. You can create a software like blockchain technology is providing that chain. Each transaction is a chain which cannot be altered, which cannot be, changed. So it's a like safe, secured kind of transaction. So these things are like the emerging and changing the way, the company or the company law should regulate. Another important concept which is emerging, which is a research concept, is the emergence of autonomous business networks. So that is a new topic. That is actually what after the company. So company is there, company is also using the technology, company is using artificial intelligence, company is using the data analytics tools, but still now the different networks, different blockchain technology related networks in a different country, and then coming together and doing business. So that is a new concept. That is the concept after technology. Now there is an ongoing research whether even they can take the power and might of the company. So this is related to our discussion on the company law, how the technology has impacted, or technology is impacting, or technology is helping in making of law, enforcing of law, and also the compliance with the law, mainly the company law. So any question before I move to competition law? Any question? If you have any question, you can ask. No? Okay.
Yes, sir. I have a question.
Yeah, please go ahead.
So I just want to ask how this technology will help in effective implementation of corporate governance code in Indian companies.
Yes. Yeah. So,
Yeah.
corporate governance in India
Yeah.
is basically focused on three, four important ideas.
Okay.
First is the independent director. So, what you are expecting from the independent director? That firstly, he should be an independent person. Second, he should be heading three important committees in a company: corporate compliances committee, a corporate disclosures committee, and audit committee. So, therefore, in a company, the disclosures are made correctly. In a company, audit is made correctly and compliances are made correctly. Now, the same work, can be performed by a software with data analytics and artificial intelligence. And it will work 10 times better. Why? Because a independent director, moment suppose you are eligible for independent director, you are LLB, LLM, so you are eligible for independent director. So, but moment how I will come to know, so there is a panel, there is a regulation, there is a law which says that, a panel is prepared by the Company Secretary Institute, Chartered Accountant Institute, those who are trained or educated or having a qualification from there. But moment I know someone, independence goes, right? There is no independence left there. So the concept of independent director is itself not independent. So that those kind of challenges can be taken by the when you are taking a technology, right? You are just saying that all the financial disclosures will be made, whatever the regulators design or the design of the parliament or the law. You inbuilt in a software, you give all the information. It will give you 100 times better result,
So, sir,
right?
in the era of this advancement of technology, why there is a collapse of corporate governance code in
Because
the
yeah.
companies nowadays?
So we have not adopting. The trouble is the challenge is not in adopting. We want a independent director who is a three generation loyalist, right? Meaning thereby somebody who has served my. If I am a director, executive director of a company, then a person who has served as a driver, as a cook, as a carpenter, and his son, daughter, grandson, granddaughter, I want as an independent director. So of course, the how what kind of corporate governance you would expect? You want a auditor, just to affirm whatever you are doing, not to question you, right? Similarly, the person you are hiring for disclosure, you are giving them instruction to disclose only what is minimum needed, right? So to hide more rather than to disclose more. But if you actually take the technology, technology will not do this. Technology will execute the task which is given to the technology. Therefore, technology can perform better. And technology has no personal relationship, has no, if, conflict of interest, has no related party. right? So technology can actually be used to ensure a better corporate governance, right?
Okay, sir. Thank you.
Hello, sir. Myself is Rajiv.
Yes, yes,
Can I
yes.
ask? Can I ask?
Yeah,
Can I
yeah,
ask one,
yeah.
one question?
Yes,
Regarding the artificial intelligence, we are
yeah,
using on the AI machines. So, can we
yes,
say that the use of AI will increase the unemployment in our country? And if the answer is yes, then how we are
yeah.
going to solve this unemployment problem in the near future?
Yes, actually, you know, artificial intelligence ideally in the certain sectors wherever there is a trouble of conflict of interest, like in the corporate sector, in the financial market, or in the governance, where you want disclosure, where you want fairness, where you want, true disclosure, complete disclosure. So technology will give you the complete disclosure. You just, include the technology with artificial intelligence, right? And then you give the task that you need to disclose whatever the transaction activity risk. It will make the disclosures accordingly.
Yeah.
Got it?
Yeah. Yeah. Yes. Yes.
Unlike you can manipulate the individual, but if you try to manipulate the technology, it will record also that on
Yeah.
this date, this time, the technology is getting manipulated. So
Yeah.
technology can actually change the landscape of governance in India, right? Yeah.
Yeah.
So moving
Thank
to
you.
the impact of technology on the
Thank you.
competition. In last
Thank
also, I
you.
will
Thank
give
you.
you 10 minutes for asking question. Now let me, take another two topics which are like more interesting and emerging than the company law. So that is the impact on competition. Actually, when the concept of competition and competition law emerged, firstly in the US and then followed in the European countries, and through the Raghavan Committee recommendation 2002 Act, we have taken. So there is a concept of market. So what is the concept of market? Market is divided into two parts. One is known as relevant product market. Second is known as relevant geographical market. Relevant product market is an area, is a territory where the condition of doing the business is the same. Now, condition of doing the business, the licensing condition, other conditions, cost also, everything is taken into consideration. So there in the law, how you will define the relevant product market. So generally it is defined in the competition law as where the products are considered as substitutes. So if you consider, let us say, this soap and that soap as substitute, so it can be considered as soap market. If you consider, this type of dress with that type of dress as a substitute with respect to what? With respect to intended use, characteristic, and prices. So this was the concept, evolved to define what is relevant product market. Now, how the technology is impacting it, as you understand, like algo trading. I will just explain it because nowadays all the trading which is happening in the even Indian securities market, it is with the help of a software. So somebody sitting on a software, a team of engineer and financial experts, they have designed a software, and software is trading with the any on the second side individuals are there. So how you will define that whether this software or that software are the part of one market or the part of a different market? Because intended use, characteristic, and prices. So even the concepts, which are given in the Competition Act to define what is market is actually not, helping when it comes to the technology. So let us say, for example, digital market. So whether the Facebook is a digital market or Amazon is a digital market, whether they are the same market, can they be substituted? Can Twitter also tomorrow, start something like this? Can it also be considered as a digital market? So with respect to the characteristic, intended use, price, so it's more catching to the physical things, physical market scenario. But when it comes to the digital market scenario, I mean, those definitions are actually not working. So this is like where this, is very difficult. It's like this coffee machine, whether it is a substitute of another coffee machine, and where the company has developed some technology, imbibed some technology. Some of you may be aware that, this KFC has developed a patent on killing of chickens on a particular method, and that they name as original recipe. So chickens can be killed by any method, but a company has developed a patent on one method. So whether that kind of chicken can we, and suppose tomorrow you, any one of you, or like us establishing the same. So can it be considered as substitutes? Can both the products be considered as substitute for the purpose of competition law? So the concept of market itself is getting, challenged by the technological developments, by the scientific development. So that is the first, impact of the technology on the market. Second important thing with respect to the, as you understand, entire markets are getting divided into two parts. One is the physical market and second is the digital market. And four companies, like one is the Facebook, second is the Google, third is the Microsoft, and four is the Apple. They are actually controlling the bulk of the digital markets across the world. They are therefore, in the 1 to 10 of the best companies or bigger companies across the world. So when these companies started coming in the market, they started creating more challenges for the development and execution of Competition Act. For example, when the Microsoft came with the first computer in 1959, then IBM series, then the personal computer, and then the programming. So what is the idea it has developed? This is a business concept. The photo says a business concept that create hardware. So Microsoft will create hardware, create motherboard, then it will create the competitive application operating system, and then it will control it through the operating system. So whenever whenever company wants, company can control everything. Hardware it is developing, software it is ready to develop, and operating systems. So operating system they are taking as a major point. So as per the idea of the company, if suppose they are coming with the Windows 2022, and somebody has developed, a software company at Pune or Bangalore has developed a software, and they are thinking that they are taking their profit or they are not sharing the enough revenue. What they can do, they can immediately come with Windows 23rd with the different features. By doing this, of course you will say that this is abuse of dominance. You are a big tech company, big company, but the company has a philosophy of doing this, that change the operating system itself. With every new operating system, in the name of changing the features, change the features so the others cannot develop. Microsoft is a developer of the platform, whereas the other small players can only develop a small, software like gaming software, like music software. So if the next window is not compatible with that, again you need to again develop or change to make it compatible. So in competition law, the many cases were filed against these big four companies. Like one of in such cases in the US, where companies said adopted a policy not to share its encryption code. Encryption code is the code which is needed to make your software compatible with the Microsoft. So there the courts have imposed the penalty. Courts have imposed the very huge penalty, and also told company not to do this. But by the time they are doing this, by the time, let us say you go to a court, you go to competition commission will pass an order, some penalty will be imposed, the company will generate the monopoly profit, and then the moment they will adopt, they will come with the new, right? So now the software is itself, now the processing system is itself new. So again, either you develop, you invest the money with your update your software in that way, and then only you can run. So that is posing a challenge actually, to the existence of to the enforcement of the competition law. So that is one case. Second important case in India also, we have the two Google cases where what the Google is doing. There are like Android version of mobile phone, and Google had customized an Android version. So Google has entered into its type of partnership with all the Android phone developer, and telling that if they are taking the Android Google, then they have to make the Google as a simple search engine. So only Google will be the search engine for that Android developer. Suppose you are a mobile developer, Lava, and you have just started your company in Pune or Delhi or Bangalore. Then you want to have the Android, Google Android. So it will say you have to take Google as a default setup. So your moment you open your mobile phone, everything will open with the help of Google. So that means what the Google is doing there, Google is taking money from anyone who wants to have their system updated or have their software, present on their Play Store and earning a lot of money, because Google has a monopoly controlling around 90% in the search engine sector and 80-90% in the field of the Android phones. So other players, like those who are the other search engines like DuckDuckGo, Bing, Info, Yahoo, they are saying that it is abuse of dominance by a company, and that too by use of technology, right? You are using a technology, you are not doing anything, you are simply entering into a contract with the mobile developer that if you are taking our version of Android, you have to make Google as a default search engine. So everything you can only download through the Google. When everything you will download through the Google will earn revenue, not from you, but from the other party, the party who wants to, list their product or sell their software on the platform of the Google or on the platform of that mobile phone. So that is how. So in India in 2018, a similar case was filed and a very heavy penalty was imposed on Google. So now the Google is giving this kind of choice after this case that even in the Google Android phone now you are getting this kind of choice that you have a choice to opt which search engine you will get, because Competition Commission of India following the judgment of the other competition commissions. But the technology, the way technologies are actually being dominated by these four companies: Microsoft, Google, Apple, and this Facebook. So, I mean, whatever you do, they search another way out. Whatever you do, they search another way out. So, unless, let us say, somebody is making a musical software, suppose a Pune, Hinjewadi based company is making a musical software and requesting Google that please list me. Google is saying, you give me that much amount. Nowadays, they are charging whatever revenue you are getting, only 10% of revenue, 5% of revenue you give, then only we will give you. So, whatever you do, right? And they are the owner of intellectual property rights. As you understand, softwares are the copyright. So Google is the owner of its software. So they say, if you want to get it, listed with our Play Store, you have to pay that much of revenue. So second case also they are paying the penalty. But every time whatever models are suggested by the competition law, they are again, coming with another changes in the technology. So technology is actually, changing the way the businesses are being run across the world and posing a great challenge to, of course, it is felicitating the company in its growth, but it is challenging to the, the enforcement of the Competition Act. Another third case, like many of you must have been observed, like in Amazon, in Flipkart, if you are purchasing the item, the lowest price is of course by the same company itself. So that means if you are purchasing an Amazon pen, so lowest price is given by the Amazon only. So or the person who is linked with the Amazon, who has a contract with the Amazon. Other will be shown where the prices are higher. So by default, you will click as a customer behavior. If I'm getting the same pen for let us say 100 rupees, another three sellers are selling 102, 103, 104, right? And the listing will be done accordingly. So the person who will give higher commission to Amazon, the person who will give higher, profit to the Amazon or to the Flipkart, only they will be like listed at the top, or only the low cost. There is no need to just say, you only say this is the low cost, same product, low cost, it is available, right? So they are just doing it and making a lot of profit. So other players, now think about these players. So they are not informed. The same product you are selling on higher, of course, nobody will purchase. Right? Rather, you are giving an opportunity to get a kind of agreement with the Amazon or get a kind of agreement with the Flipkart and that get listed on the lowest type, right? Unless you are ready to share your bulk of the profit, of course, they are not happening. So many such cases are, happening around the different countries, leading to, imposition of penalty. But penalty amount is 100 crore and the profit is 10,000 crore. So companies are happily, happily giving the profit, happily paying the profit to the commissions. So this is another, third type of. Now, fourth type of, the development which is happening in the field of competition law, enforcement of competition law is the, the kids nowadays, they are playing even in the Android, the PlayStations, Windows, Mac. some games, computer games, PUBG is there, many games are there. Now in Apple, what is being done that you can only download these games through the Apple Store. There is no system of Google Store. So when you are downloading the system through the Apple Store, what Apple is doing, Apple is charging very high commission from these software developers, these game developers, right? So some of the game developers, filed the case saying that what is this, because in Apple mobile you have no choice from get it downloaded from the Google Store, because Play Store is not there, is the Apple. So that is like creating another type of enforcement related trouble. So again the penalty was imposed on the the companies like Apple. And then another third, in competition law, like though some of you or most of you are aware that cartelization is prohibited. What is cartelization is that same businessman in the same business, you cannot fix the price. Suppose if I'm going to a Navi Mumbai market or a Mumbai market or Bandstand market of Mumbai, and I just want to, let us say, purchase some item. So all seller cannot fix the price and then sell the goods or sell the services. So that is prohibited. That is known as cartelization, where the businessman, they are sitting together, entering into an agreement and trying to fix the price or divide the territory and then selling it. But now that it is prohibited, when they are doing it, they are entering into an agreement. All market, everywhere it is happening, but it is prohibited. It is an illegal activity under the Competition Act. But what if, like when it is done through a system of software, like a case was filed against Ola and Uber in the different jurisdiction related to this. They are doing the same thing. Suppose if today in Mumbai, it is raining. So what they are doing, all the Ola through the software, all the taxi owners, because only they know what is the cost. Suppose if I book a, let us say Ola for going from, let us say the, BKC to Navi Mumbai, a place in Vasi. So all they have started, immediately the fees they are raising. So so why? Because they are in a position, they are a hub, they are a software, and there is a spoke, different drivers. You can take the different drivers there. So whatever price you give, that I have to accept. So it is also a type of allegation was made on the Ola and Uber that it is a type of cartelization through the technology, through the hub and spoke kind of cartelization, because all drivers are competitors, right? Individuals are like on a very receiving side, they have no say. So on a normal day the price is different, on a rainy day the prices are different. So otherwise, and you say that the drivers, all the drivers in a normal case, they are prohibited to enter into a sort of agreement, understanding, arrangement whereby they can fix the price. But the same thing is done by the technology now, because all the drivers are either linked to Ola or Uber. You don't have a third choice in a city of Mumbai. Now the other taxis are there, but on the rainy season, those taxis are not there. So there was an allegation, but in the case in India, I mean, it was not identified. The evidence was not there. So it was, but there is, that is like in other countries, the cases were filed and the court or the competition enforcement authority, they have imposed the penalty that you cannot, like whatever is prohibited, that means you cannot do it offline, that of course you should not do it through the software, that you are creating a software. Now software you are able to understand. So now I cannot get any, suppose if I'm traveling from this location to that location, so whomsoever I try, that price I have to pay. So I am like optionless. Even drivers are also optionless, because they are also the part of a type of a software, and software is in a position of a hub, and thereby fixing the price among the competitors. So therefore it can be considered as a cartel. So that is another trouble, another challenge which is posed by the technology in the enforcement of the Competition Act. So so what are the solutions actually in the other jurisdictions they are coming with? They are coming with now Digital Markets Act. They are coming with the law regulating the technology, law regulating the gatekeepers liability. That means if you are running Ola, so put some liability on Ola, that Ola cannot do this. Then you are running Google, you can put liability on Google, that Google, what are the liabilities of the Google? If you are running Facebook, if you are running Twitter, you have some liability. Then the digital, some of the countries have came with the Digital Markets Act to deal with the technology and specialized unit and other things. So these are the possible solutions. But as but whatever solution or whatever drafting you will make with respect to this technology. Again, next technology will come, next advancement will come, next development will come, and then your existing enforcement framework will not be in a position to actually, help you in that regard. So this is with respect to, only impact part I have taken. What is how the technology is impacting the enforcement of the Competition Act. Now, any question there? Please feel to ask any question. Yeah. Any question?
Sir, I would like to ask one question. Sir,
Yeah.
related to competition law,
Yeah.
is it sufficient law for consumer? I didn't see the rights of consumer or safeguard
Yeah.
under the
Yeah.
competition.
Yeah. What happened, Pragati? Previously in 1969, we had a law known as MRTP Act. Under MRTP Act, both, yeah, right? For unfair trade practices, the consumers would have filed the case. But when the Competition Act 2002 was enacted, specifically the jurisdiction to deal with the consumer matters was given to Consumer Forum. So that is under the Consumer Protection Act. So Competition Act is now intended to only protect the competition. Thereby, indirectly it is protecting, but directly the prime object of the Competition Act is to protect and promote, sustain competition. So for consumer matters, now if individual deficiency of service, so now there are two situations. Suppose you purchased something, but there is a problem in the product. So you can go to local consumer forum under the Consumer Protection Act. But if the problem is due to some anti-competitive agreement, or if the problem is related with the abuse of dominance, in that case you can make a complaint to the Competition Commission of India. But in a normal matter, the jurisdiction is given to the Consumer Forum, State Commission, and National Commission under the Consumer Protection Act. Is the point clear?
So yes, I got it. Thank you, sir.
So
Yeah.
I have one question. So I have one
Yeah,
question.
please.
I would like to ask, what is the digital transformation and its influence on the competitiveness of the companies?
Yeah, digital transformation is moment you use the technology, because company, as I told you, is a device of technological brilliance and financial brilliance. So
Yes.
moment you are making the digital transformation, let us say a company using technology, artificial intelligence, data analytics, algo for decision making, for implementing, for compliance. Of course, the possibility of growth will be higher. Firstly, it will reduce the transaction cost. Keeping 100 individuals for a job and keeping one software for a job, of course, it is cost effective. Secondly, of course, you will make it more third, from the governance point of view, you are like more disclosing to, your disclosures are more fast, more speedy, right? It is like whatever command is given to the computer will do it. So you are more, more investor friendly also, more consumer friendly also. So it is going to change actually, the landscape of the companies are going to get changed through the digital transformation, right?
Yeah.
Yeah. So now moving to, the third concept, the financial market, that market where like I am there, like we are SEBI Institute. SEBI, as you understand, is regulator of the securities market in India. So market, as you understand, its entire market is digital, right? There is nothing physical, no physical thing, right? So financial markets are moving to the technology only. So if you want to, let us say, purchase the shares, what you need to do, you need to go to a bank, have a bank account. How you can open a bank account? Go online, get your eKYC done, your account will be open. Then you go to the Zerodha, many brokers software. Open again, eKYC is there, you will have a trading account, you will have a demat account, and entire market is like this. I'm just giving you one fact. Like many countries where the securities market are not developed as that of India, they're coming to our institute to have training. 160 countries and their offices. So when they want to, go and take photographs. So in Mumbai, NSE is there, BSE is there, SEBI is there. Everywhere, what is there? A computer. So at the end, they are saying, we came here to, just to know what is the securities market of India. And you are just showing one computer. So that is the securities market of India. One supercomputer, big computer, more machines, more USB, bigger spaces, but it's only computer. So this entire market actually is dominated by the technology, actually regulated by the technology. Now, some of the innovations, like I think some of you might have heard about the peer-to-peer lending. What is peer-to-peer lending? Initial system of banking was that, you go to a bank, give the money, bank will work as an interest intermediary. Interest intermediary means one person is coming, giving 100 rupees, bank will give him 4% rate of interest. Same 100 rupees, bank will give to other person who come for lending on 8%. So bank is just simply working as an interest intermediary. Now the emergence of technology had changed the concept and provided you a platform known to peer-to-peer lending. So if you have 1 lakh rupees, what you can do, you can divide 1 lakh into 10,000 into 10 and go to, download a software of the peer-to-peer lending, a fintech software, and then lend your money to 10 persons. Whatever is available to the banker, that is available in the software, like his name, detail, KYC, his civil score, everything you will get in a software. And transaction cost is how much? Only 100 rupees to 500 rupees. Generally, the bank charges higher transaction cost. So 2-3 years before this concept came, so it was thought that, it will take the business of the bank. But due to the recovery issues, some recovery issues, some trouble, even if the person had good civil score, right? Still he may default. So due to those trouble, still it is not growing the way it should have grown. But the concept is growing. There are like more than many companies and the volume of transactions are going on the peer-to-peer lending. And second, unlike bank only take civil score and whatever information you give. It also, analyzes your social media profile, how much information you are posting on the social media, what kind of post you are making, whether it is like, what time you are posting. So if let us say somebody is posting from 10 to 5, so that means he is not suitably, implied or engaged anywhere. So automatically his score will be, social media score will be negative, right? If somebody is only posting about the growth of economy, growth of the sector, that means he is positive, not in the. So even the social media profiles are also being analyzed by the peer-to-peer lending software along with the civil score. So of course, this is a one of type of the technology which is like helping both the lender also and the creator also. But technology is helping, but of course India is a big country, it will take more time to develop and get it matured. But this is like one. Then as you understand, now the RBI itself came with the concept of digital bank, digital currency, central bank digital currency, following the models adopted by many countries. So what is the model? Many of us are accustomed to now the payment gateways. India is like among world leader in payment gateways. Like, any place, wherever you go, even at a village, even at a, very a small item, 5 rupees item, you can pay through Paytm, you can pay through Google Pay, you can pay through this. Rather, it is being paid through this, right? Unless the cost of the item is 0, like 100, 150, 200, 500. Generally, people prefers to pay through the payment gateways. On the same line, now the RBI is coming with the central bank digital currency, where a digital ballot is given to you, equivalent to e-currency, and whatever like from your e-ballot money you give to others person, it will be created into his e-ballot. So this change is helping whom? You also, the other party also, the system also, economy also, and regulator also. How the regulator? Regulator no need to go print the currency, transport the currency, keep the currency, have currency chased across the country, get the money deposited, physical, a lot of, and then there is a trouble of the black economy, parallelly run economy. So you are just central bank digital currency, your money is equal, whether it is digital or physical. You have a purse. Now you don't need a purse, you need a mobile number which is linked to your Aadhaar card. That's it. Even if you are not carrying mobile, it will work, right? You can get connected, you can transfer. So this is like, another type of advancement in the banking sectors, in the financial market. Then robo advising. I already told you most of the brokers, most of the big securities market institutions, company, they started adopting robo advisors because the most of the basic advice are needed by the normal customers are of the same manner. So if you just take one software and give the power of artificial intelligence. So suppose the software has already advised to more than 1 lakh person. So it would be in a position to give you a better advice based on both the input, technical inputs, and based on its processing, the way it has answered in the past. So similarly now how to the second part, how to develop. So second part is the regulatory sandbox, innovation sandbox. That means if someone is capable of developing a software for peer lending, somebody is able to develop a software for with respect to payment gateways, somebody is able to develop a software for giving robo advice, somebody is able to give you research analysis. If you want to invest, it will give you all the type of analysis. Just you click want and minimum fees, or even free. Some of the companies are offering initially for free in order to empower their artificial intelligence. So how you can do it? Then for that purpose, you need to go to regulator, go with a software. Software will be tested through the regulatory sandbox. That means whether it is compatible with the rules and regulations, it will be tested. After that, you can launch. And regulators are encouraging it actually. The more you do accordingly, you will be encouraged. Similarly, as I already explained to you in the beginning, that there is a time of bitcoins, as you are already seeing through the blockchain technology. The technology is itself creating the currency and giving it. But the trouble is, since the KYC is not there, jurisdictions are different, enforcement of law will be different in a different jurisdiction. So therefore, the regulators are not adopting the bitcoins, but initial coin offering and token offering likely to in the coming years, they are likely, our regulator is also likely to take these kind of, they have now come with the regulatory sandbox and innovation sandbox, where anyone who has developed a software and try to test it can come to a regulator will give him a platform, it will be tested, then you can come and launch it in the market. Any product like peer-to-peer lending, robo advising, robo counseling, right? So these are the type of the development and advancement of technology. So now coming to the securities market, I mean it will take more than the time given. So, but still the reforms, most of the things in the securities market, as I already told you, are driven by the technology. So when it comes to corporatization, demutualization, segregation, like in a stock exchanges, it is required that who is the person who is the owner should not be in the managerial capacity. If you are managerial, you cannot be in the trading capacity. So all three should be separate. How you can do? Make the software, customize the software. Software will not let you in. Put your PAN card number, your relative, PAN card number. Make a database. Put in the system. System will not let you to do the trading. So this sort of thing can be very easily achieved through the technology. For DC, the dematerialization of security. Yes, many of you must be knowing the time when it was the paper security. Let us say, presume a person in Delhi trading with a person in Kolkata, and the stock exchanges are there in Mumbai. So the broker in Delhi, broker in Kolkata, firstly they will through the broker you can contact. Then the contract note will be prepared. Copy of contract note will be sent to Mumbai. So time, delay, possibility of destruction, right? Possibility of loss of value, many things can be there. Now, demat and also the numbering for company also is the headache. You have to give numbers, share number 1, share number 2, share number 3. Now it's like a currency, right? Now, and company is not supposed to do it. Who is doing it in India? NSDL, National Securities Depository Limited. They are converting and then they are conducting everything. So at today, like somebody wants to know how many shareholders are there in Reliance. NSDL 330, when the market is closed, NSDL will give the data, who are the shareholders for, so anyone, let us say if the company has a record date for giving the dividend, automatically it will go to that person, no dispute. So complete dematerialization. As you understand, Indian securities market, now only offer can be made in the dematerialized form. All the trading can take place only in the dematerialized form. So that type of technological advancement we have already acquired, and now we are moving one ahead far. Other countries, are having, let us say, the T2, T3. US is coming with the T2 settlement. That means if you are trading today, excluding tomorrow, day after tomorrow, your trade will be settled. But we are now coming with the not T2, even T1. Today you do the trade, tomorrow from my demat account, share will be created to your demat account, money from your bank account will come to my bank account. So this is like, the type of the technology, making it so liquid, your investment so liquid and so helping. Then, as I already explained to you, algo trading, right? You develop an algo, a software, software will take the command and software will, do the trading for you. So algo trading and high frequency trading. Now 70-80% of the trading in India is actually one side it is the computer, second side it is the individual. Why? Because those who have money, for them now they are not hiring the individual, they are hiring a algo. And algo is supported by a team of the software expert and the financial expert, a very small team. And they are just, just changing the codes and everything. They are generating a very huge profit, and also it is helping in the development of the Indian securities market. Then listing and issuance, everything is now computer based. You make the file, complete the formalities. If 3 year requirements, if you are able to complete, you make the folders, fill the, submit it in a particular format. Automatically, software will analyze whether you have all the necessary requirements or not. Meaning thereby 3 years of profit, other, the return, your disclosures. If not, it will create a red mark, and accordingly the notices will be sent to the concerned company. Then compliances. The compliances also now the, entire technology is helping the way ahead. For example, I'm just telling you, somebody is trying to manipulate our securities market. There is a software used by the market regulator, which is known as suspicious transaction report. So any unusual trading, like suppose you are not trading from last 2 years, suddenly you today traded for 1 lakh rupees, or let us say 10 lakhs, more than 10 lakhs. Immediately it will generate suspicion. So somebody will investigate, software will investigate from where the money has come, how you have, invested. So if some mismatch, some trouble, some suspicion is there, then automatically, you will be investigated. You may be aware, may not be aware. Moment you are doing something unusual, the technology will catch it, detect
Hello.
it, investigate it, and generate a report for you.
Hello.
And then it is like helping the regulator in actually
Hi.
enforcement of the, compliance. So yes. So moving to my last, I think I have already,
I'm now not looking for any property.
okay. So coming to the last, my last important point, that now the SEBI on 30th July, just 2 days, 3 days before, came with a regulation related to online dispute resolution mechanism. Why it is important? How it is important? It is important reason being, as you understand, Indian courts are cursed as like having 5.5 crore litigation. So if you like go and file a case in UP, it will take 14 years. In Delhi, it will take 6 years. In Mumbai, it will take 3-4 years. So different depending on the number of pending litigation, your case will be decided. So now, financial markets are already using the technology. Previously, the different, like in the banking ombudsman, there was a system RBI, you can go and file it. Similarly, SEBI uses a system known as the scores for consumer grievance redressal system. Now, on 30th July, just 3 days before, they came with a concept of online dispute resolution. That means software will create a platform where, like, whatever, suppose somebody is having some grievance, he will, make a complaint. Then it will go to the concerned, the person against whom the complaint is there. He has to file his reply then and there. Firstly, he will try to connect with you and try to resolve it. If not, then he has to say whatever he has to say. Then it will go to the suppose the person with whom he is linked. Suppose the person is a broker, you have a complaint. It will go to the stock exchange like NSE or BSE. So there the grievance redressal officer will give his comment, either decide it in your favor or try to do the mediation, conciliation, right? Only through the software, and everything is recorded by the software. Then if it is not resolved to that level, then it will go to the arbitration, online dispute arbitration. So again, arbitrators will be sitting at the different places. You again, whatever evidence you have, whatever claim you have, that you need to submit, whatever defense other parties have, right? In the mean, there is also, they have come with a system of neutrals that they will try to resolve by saying you that if your, let us say dispute is genuine, how much compensation is reasonable, not reasonable, then informally, telling the other party. So that type of software-based, online dispute resolution system is now launched in the securities market, and this is like going to change the way, the justice should be delivered in a, country which is like overpopulated, having more than 1.40 crore of population. Otherwise, otherwise you file a complaint today, you will get after 12 years, 20 years. And what is the point of getting the dispute? So if it is succeeded, if this concept succeeds, it's already worked well in the RBI, already worked well in the score system, but now they are, it's like a unified portal. One portal, everything is there. So the arbitrator can also look at the, what are the, claims, what are the responses, what is the evidence with the, complainant, what is the reply, and what is the evidence with the other party, everything on one software. So the decision will be quick. He has to write the decision, right, within a given time framework. He has to decide, and for everything, columns are there in the software. Software is getting developed. So this kind of system, on 30th July 2023, India is going to adopt mainly in our securities market. And I'm 100% sure if it creates success, it is going to create a success story. This technology is going to create a success story also for the system of the courts, for which the Niti Aayog and others, they have already racked their brain that can this kind of system be, implemented in the public court. So since time is there, so I think quickly, if you can ask, if you have, you can ask one or two questions. Otherwise,
or if sir will permit us, we will send all the questions of participants.
Okay. Sorry, madam. I actually just 3-4 minutes.
No, sir, not at all, sir.
Yeah.
Sir, as sir has rightly stated that with the help of this software or with the help of this technology, we can cut the time of our litigations, which will obviously the time is affecting the cost of litigation. That's why it is most important. So thank you, sir, for joining us and for your valuable time. On behalf of Postgraduate Teaching Department of Law, Rashtrasant Tugudaji Maharaj, Nagpur University, I would like to extend my heartfelt gratitude to our esteemed guest, Dr. Rajesh Kumar, sir, to share his expertise and knowledge on technology and its impact on corporate laws and competition laws and financial market regulations. Sir has very well explained the concept of company from the science and technological development, then how technology affecting the competition law, and last but not least, the securities laws as well. So thank you so much, sir, for enlightening our research scholars and spare your valuable time. Thank you, sir.
Thank you, madam. Thank you.